Israel has to withdraw in favor of the Palestinian people, as the relevant resolutions of the Security Council and the General Assembly have required constantly. The holy places have to be freely preserved and open to all those who wish to go there. And that's not negotiable either. Disregarding these legal imperatives shared by all nations, Israel would like to legalize its unlawful actions, which I've just mentioned, by placing them in an agreement. Yet if one subjects the situation to legal analysis, what becomes apparent is that Israel has no right over Palestine, only duties. And the preservation of international public order based on shared, non-derogable norms depends on their being complied with. The responsibility of this compliance falls to the United Nations, which is mandated with peacekeeping. They have been confronted with Palestine's decolonization case filed by the failure of the mandate given to the UK. The UN is the only authority capable of resolving on a legal basis the situation created by decades of failure. And if peace must come from an agreement between the parties, this must be concluded under the auspices of the United Nations, guarantors of legal compliance, and not under the arbitrary sponsorship of a third state lacking in objectivity. Thus, the way forward, based on the findings of your opinion, should ensure that the agreement re-establishing the Palestinians in all their rights will respect the fundamental norms which currently are the target of circumvention. If that weren't to be the case, the future peace treaty would fall under the Vienna Convention of the Law of Treaties, which provides, I quote, "A treaty is void if at the time of its conclusion it conflicts with the peremptory norm of general international law." End of citation. This brings me to my last point, the second question, which is being put to your court by the General Assembly of the UN. You are asked about the legal status of the occupation and on the legal consequences arising from it. You must thus examine Israel's occupation of Palestinian territory holistically in the light of international law. Well, first of all, it's jus ad bellum, the law which governs the use of force by states. This includes the very important norm of the prohibition of the threat of use or use of force against the territorial integrity or political independence of any state. Now, it is established that it is by the use of force that Israel occupied Palestine in 1967, as the Security Council and the General Assembly have ceaselessly recalled.
These were parts of the hearings of the ICJ on the legal repercussions of the violations of Israel in the Gaza Strip. Our dear viewers throughout the day will be covering these hearings here on ITV International from The Hague.